Welcome to Solving Citizen Legal Encounters. All right, we're back with the Sachs case that we've been following. There's 2 hearings in this video, so we're going to go through and check out how things progress, and then you can make your comments. We'll take it from there. Let's go.
Oh, we have the interpreter here. I'm sorry. Page 20, Zhang, C 345540. And do we have Ms. Zhang online?
张小姐，你上网了吗？喂，喂喂喂，张小姐，
They usually do appear together on both meetings.
Ms. Zhang, are you there?
张小姐，你上网了吗？喂，张小姐，你在视频上吗？
Mr. Sachs, if you can hear us, please unmute your end.
Ms. Renetti, do you want us to call this in on another day? I know you've been waiting, but I'm going to take care. I mean, I'm ready. I've reviewed everything.
Yeah, and I understand that, but I know Ms. Madam Attorney must leave, so, and I know Ms. Zhang definitely needs an interpreter, so I'm fine with continuing it.
All right, we will continue both matters. Ms. Zhang, page 20, and Mr. Sachs, page 21. They're not responding. They do appear to be on. We've sent them a chat for the record. We've called their names numerous times. They're not responding. So we'll pass this matter to Tuesday. Is that her next available date? Again, assuming that's available for her.
Wednesday the 3rd.
Okay. Actually, Wednesday.
We'll do January 3rd at 9:30.
All right, thank you.
We do have the Spanish interpreter back.
Okay.
Page 6.
Just advise them of the new date because they did not respond. I don't know if there's a problem with the electronics or on their end, our end, but the DA handling the case.
Excuse me, sir.
Is no longer present. Yes, Mr.
Sir?
Is this Mr. Sachs?
I believe you're talking about our case, and I just want to have the benefit of asking you directly because we have asked it to be recalled because on your end you had technical difficulties, and then I have the chat function up on Blue Jeans where the court clerk Jay Sanson at 11:13 p.m. our time said, "We will recall your case in a moment." We have been sitting patiently now for over half hour, sir. So I would really appreciate if you would just handle this matter because you have already, not you, but this court, this business has wasted about 2 hours of our time. 2 hours and 15 minutes. So we would really like to get our business taken care of today, sir.
Okay. The deputy DA who is handling this case is not present in court. And I am not going to go forward.
Sir, is that my fault?
Do not
Is that
interrupt
my
me,
fault,
sir.
Now, as you can see from 2 years ago, he still had that same anger. And also in the recent case that I posted, we wasn't sure why he was doing all the talking because of the situation. I don't want to give everything away for the people that haven't seen it. But she doesn't speak English.
One of the things that you would have been told when you went through a Ferretta canvas is that you follow all the court rules. And one of the court rules is that all attorneys follow is that they do not interrupt the judge. I was speaking. Let me finish. The deputy DA handling this case was here and waited just like you. She is now gone because we had technical difficulties here. We sent a chat to you and we called your name and we did not get a response. I am not blaming you. And I don't know if it was all related to the technical difficulty of the equipment or you didn't hear us or whatever. I'm not blaming anyone. The bottom line is I'm not going to hear this case without an attorney being present, as I would not hear the case with you not being present. So we have rules on both sides, okay? So we're going to follow the rules and the rights of each party. So we continue this matter so the two of you can be present and the deputy DA handling this case can be present, and we'll give you that date and time again. Here it goes.
That's January 3rd at 9:30.
Okay, and that is for both parties, Zhang and Sachs, correct?
Correct.
All right, thank you. We'll see you back at that time, sir.
Sir, I have a right to make a record, and I'm making a record. I strongly object, and the reason is that the court clerk, when she wrote to me...
Sir, I've already ruled.
When she wrote,
I already heard that. I have ruled. We've continued this. The DA cannot respond because they are not here. I did not handle your case when we couldn't hear you, and that would not be appropriate. All right, thank you
Sir,
very
the
much.
question-
Please have a wonderful day. Is that our last case for today?
We have 6:17.
As you can see, the judge didn't want to hear anything else after he made his final statement. And also for the next hearing that they mentioned that was January the 3rd, there was no January the 3rd, so we had to move on to January the 17th. And you know how it is. Sometimes these hearings get rescheduled and you don't know. But we're going into the next one. Let's go.
Mr. Sachs, are you there? Calling case 343540, State of Nevada versus Kimball Austin Sachs. Mr. Sachs, are you there? Want me to continue it or you want me to go forward?
Ma'am,
There we go. All right.
ma'am, I apologize. I apologize. I accidentally hit the uncall button and I hit I meant to hit the unmute button.
All right, not a problem. All right. Calling case C 343540, State of Nevada versus Kimball Austin Sachs. I have Mr. Sachs present on Blue Jeans, and I have Ms. Renetti here in the courtroom. I have this down for two motions that were filed by Mr. Sachs. One was defendant's motion for the court to provide the long overdue findings of fact, conclusions of law for two court filings from Judge Carly Kearney pursuant to EDCR Rule 1.90A4. The second motion was defendant's motion to compel Prosecutor Dina Renetti or the court administrator to provide the court model jury questionnaire and model jury instructions and grand jury rules and bench book pursuant to EDCR Rule 1.50 and voir dire the court pursuant to the Constitution of the United States. The court has read through everything. I am a new judge on this case, so I did in fact go back and look at the history of the case, and very specifically the transcript from the last hearing, as well as the motions and what was cited in the motions. And I am prepared to rule today, but they are your motions, Mr. Sachs. So is there anything other than what was contained in your motions that you would like the court to consider before I state what the court's inclinations are?
Well, what I would like to do is actually ask the questions that were contained in the motion for the jury instructions and other things like that, because the other one in my mind is pretty straightforward, meaning the findings of fact, conclusions of law. That's pretty straightforward. But again, I have specific questions to pose to the court with respect to that second motion, the one for the type instructions that would prepare me for a fair trial.
Okay. Mr. Sachs, it is not appropriate for you to question the court about things that involve legal issues. The court is not allowed, pursuant to the law, to provide you with legal advice. If you have questions in regards to model jury instructions or jury questionnaires, those are appropriately obtained by the jury instructions are online. That you can find them by looking them up, or you can reach out to the self-help center and they can help you. But the court cannot provide you with legal advice, and it is inappropriate for you to ask the court questions. I can certainly answer procedural questions, but I cannot provide you with any advice that would be legal advice, which gets into the issue of why Judge Kearney offered to provide you with standby counsel, I believe, to try and help you, assist you potentially in answering some of those questions that you might have. So that's where we're at, but it's not appropriate for you to ask me questions that would require the court to provide you with legal advice.
Now, you would think since he's doing all those Google searches on the law that he would know that he can't ask the court those type of questions.
So if you have any questions that would not require the court to provide you with legal advice, I am happy to answer those questions. With that understood.
Thank you.
Do you have any questions?
Thank you, ma'am. So really the follow-up would be is I fail to see how asking for the model jury questionnaire, the model jury instructions, the rules for the grand jury, and the bench book are advice in any way, shape, or form. My understanding is this is a public court and that these are public documents, and I'm just simply asking for the source because the 8th Judicial District Court does not provide these documents on the site that I could see, meaning the 8th Judicial District Court, when you go to it. They actually have some type of assistance for civil cases, but they don't have anything for what I'm asking for criminal cases. So it seems to me that's actually unfair right off the bat. So again, I fail to see, ma'am, how does asking for the jury instructions, the jury questionnaire, the rules for the grand jury with respect to the roles and responsibilities of the prosecutor and the defendants and the bench book, how does that even come close to being or considered legal advice, ma'am?
Okay, and let me explain to you on two of those. The jury questionnaire is not something that is created by this department. The jury questionnaire is something that is created by jury services.
Ma'am, I can't hear you. You've gone silent.
We aren't muted, so it must be on your end. Can you hear me now?
I didn't touch yes, I can hear you, ma'am, but I didn't touch my phone, I assure you.
Okay. The jury questionnaire is not something that is provided by the department. The jury questionnaire is something that is created by jury services. If there is even a jury questionnaire that is done, ever since COVID, there has not been jury questionnaires that have been done. So, and usually that is something that is created by the attorneys that are involved in the case that is presented to the court. It is not something that the court creates. As it pertains to the jury instructions, there is a book of jury instructions that is available out there, and also similarly, those jury instructions are usually jury instructions that are presented to the court by the parties as to specific jury instructions that the parties either agree to and or that they don't agree to, that then the court, once they receive those jury instructions, does what's called settling the jury instructions and goes over the jury instructions with the parties prior to trial, and then before towards the end of trial, before we read the jury instructions to the actual jury, we do what's called settling the jury instructions to make sure that the jury instructions that are provided are in accordance with the facts and information that were provided during the trial. As it pertains to the bench book is created by the court and is the judge's own work product. All of us have different bench books that simply has statutes and court rules in it that we utilize for our benefit, and it's not something that is given out to the public, and it's not something that is appropriate to be given out to the public. It would be similarly if you had an attorney that was representing you, Mr. Sachs. It would be like me asking for that attorney to divulge his notes. It is something that is utilized in various different cases and is for the benefit of the judges to make sure that we cover all of the different things that we need to cover when we are handling a case. As it pertains to voir dire is similarly something that is that you create. Voir dire is a method of weeding out impartial or jurors that could be potentially partial, and it's questions that you all come up with, that you can come up with on your own, that would be asked of jurors to assess their ability to fairly and impartially judge your case. There are very generalized questions that the court will ask, but pursuant to EDCR 7.70, it is a method by which you are attempting to weed out jurors in your case that might be biased or not impartial in your case. And so it's questions that you create on your own. And there is no basis for you to voir dire the court. The purpose of voir dire is, as I indicated, for you to pose questions to jurors. It is not to ask questions of the court. And that is pursuant to.
Ma'am, to just follow up on that, and thank you for that,
Sure.
is how can it be considered inappropriate for me to ask you, have you taken your oath,
I would love to see a judge say none of your business.
and what day did you take your oath, and specifically where on file may I obtain a certified copy of your oath, ma'am?
Because that's not voir dire. That's not the purpose of voir dire. Voir dire, the purpose of voir dire is, and you can look up EDCR 7.70. EDCR 7.70 defines what voir dire is, and the purpose of voir dire is to ensure that you get a fair and impartial jury, and that is questions that you would pose to the jurors. By virtue of me sitting here, I have been deemed to have taken my oath by the Supreme Court of the state of Nevada. So my ability to sit here is created on my duty to take my oath, but I did take my oath on, I took the bench on January the 4th, which would have been a Monday. So January the 2nd of 2021 is the date that I took my oath of office. 4 year.
And how do I get a certified copy, ma'am, of your oath?
I believe that those are I believe that those are on file with the county clerk, but I am not 100% sure, sir. I know that I took it,
All
I
right.
signed it, and I know that it was signed by the judge who I took my oath in front of. There was a secondary oath that was taken because I took the bench in 2021, so my investiture happened because we were in COVID timeframe. My investiture happened in September of 2021, but my oath of office was taken January 2nd of 2021. I believe that it might be with the clerk of the court, or it might be with the registrar's office. Maybe, I know it was Lynn Goya for a while, but I'm not sure who would have that. So, but that's the information I can give you on that issue as it currently pertains. As it pertains to the court to provide your motion to provide the long overdue findings of fact and conclusions of law from Judge Kearney, there is no requirement pursuant to EDCR 1.90A4. It just says that judge has to issue a decision, which the judge did issue a decision in this case. And so she was not required to do findings of fact, conclusions of law. Findings of fact, conclusions of law are referenced in 1.90A5 after the trial on the matter has completed, or if there's an evidentiary hearing. But it's my understanding that there was no evidentiary hearing, nor was there any trial yet. So all she had to do was issue a decision, which she did issue that decision. And so therefore I was going to deny that motion as well. And I was going to, for all of the reasons that I've already stated on the record as to the other motion, I'm going to deny that motion as well. So.
Ma'am, I just have some follow-up questions. Then why did the other judges, meaning the previous judges, Judge Silva and Judge Lily Spells, provide me with the findings of fact, conclusions of law, if that's what you're maintaining, ma'am?
Because every judge is allowed to do things differently, and if they choose to issue findings of fact and conclusions of law, they may do so. They are not required to do so, though. Sometimes they will do so, unless there are specific instances where they are required to do so, which is if it is a writ of habeas corpus, there is a requirement under, I wrote this down, give me 1 second here. I believe it's NRS 38.340 is the requirement for, if it's a writ of habeas corpus, that you are required to do findings of fact and conclusions of law. Findings of fact and conclusions of law will also be appropriate if you have a situation where the court actually made findings of fact. So if the court, and that is so that the appellate court will have a sufficient record to be able to see what the lower court did. So I don't know how, what the issues came up with in front of Judge Silva or Judge Spells. I am not in their heads. I did not speak to them about your case because that would be inappropriate for me to ask other judges what they did on your case. So, but I can tell you that if it is a writ of habeas corpus, or if there is an issue where, as I indicated before, an issue where the court feels that it's necessary to make findings of fact because they will need to, the appellate court will need to have those findings, then it would be appropriate in those instances to issue findings of fact and conclusions of law. But in this particular instance, from what I could see, your motion was a motion to dismiss based on jurisdictional grounds, which did not require findings of fact and conclusions of law. And that is the reason why Judge Kearney simply issued a decision. That is my guess. Again, I am not in Judge Kearney's mind, but that would be my take on the situation.
Solvent citizens, as you know, always want to go through this thing of filing motions to get cases dismissed. They know it's not going to happen, but they always want to try to get things stretched out. And this type of case needs to be handled sooner than later.
Thank you for that, ma'am. So you mentioned somewhere in that answer is
Mr. Sachs?
yes. Yes.
I earned the title of judge. I would appreciate it if you used it. I'm not a ma'am.
Oh, I like that. Tell them, Judge.
I said ma'am. I didn't. I said ma'am.
I know. I know you said ma'am. I am a judge, or I am your honor. I am not ma'am.
All right. If it suits you, Judge, I'll go ahead and address it that way. So, Judge, in your answer, you said that Judge Kearney did say that it was written somewhere. I didn't see it written anywhere. Where would I find her written decision? Because I didn't get anything in writing. In other words, I'm not in receipt of that, Judge.
So, hold on. Let me pull your case up and I'll tell you exactly where it is. Give me 1 second, Mr. Sachs. I just need to get to it. This is a pretty long history in Odyssey, so give me 1 minute.
Thank you.
Looked at it last night. All right, so on September 5th of 2023, an order was entered. I will read it to you because it's relatively short. It says, it is hereby ordered that the defendant's motion to correct the recorder's transcript of the hearing held on July 24th, 2023, pursuant to NRS 656-250, and motion to dismiss charges as the court is deprived of in personam jurisdiction pursuant to the contract clause of the United States Constitution, and defendant's motion to acquire my complete case file that was due from the rogue attorney Ben Nadig on July 28, 2023, and to sanction Ben Nadig pursuant to NRS 7055, shall be court ordered matter set for status check for Mr. Nadig to provide confirmation that case filing was sent. Court indicated as to defendant's motion to correct recorder's transcript, it had the recorder review and correct any clerical errors and file an amended transcript with an errata attached explaining the changes made to the transcript. Court further ordered motion to dismiss charges denied. So that was signed on September 5th of 2023, and it is in Odyssey.
We knew that response was coming.
In Odyssey, I was not provided a copy. Is it not true that the orders and such things, documents like that, are they emailed to me via the normal way that I get notifications from the court?
No, if you are you need to register for file and serve, sir. And when you register for file and serve, then you will automatically receive anything that is filed into your case through that file and serve.
Thank you for that. The one follow-up that's very pressing, though, that I do need to ask the question,
Sure.
Judge, is what law of the case, other than what I've been, say, falsely charged with, the NRS 200.508, what other law of the case is going to be, say, mentioned or discussed to the jury? And I asked that question knowing ahead of time, in other words, seeing this as a very rigged game, ma'am. That's my position, is that the jurors are going to be instructed on the laws of the case. And so in order for me to prepare a proper defense and to obtain a fair trial as best as I can, I'm asking the question, Judge, what law of the case is going to be mentioned to the jurors, please?
And sir, we're not in trial. So you are being charged per the charges that have been issued against you, which I'm aware that you've already pled not guilty to those charges, correct?
That's correct.
All right. So you know the charges that are being brought against you. When you go to trial, in order for you to prepare for trial, you need to prepare to defend yourself on those charges as the statutory charges that were brought against you. And then you will create jury instructions because you're representing yourself, you will create jury instructions that you will provide to the court, and the prosecuting attorney's office will prepare jury instructions. Usually what happens when you have a defendant, usually they have a defense attorney that usually meets with the prosecuting attorney and goes over what they think are the appropriate jury instructions to provide to the jurors. And there's usually a group of stipulated jury instructions that you come up with, as well as non-stipulated instructions. The court listens to the evidence that is presented at the trial, and then based on the evidence that is presented at the trial, will instruct the jury based on the evidence that is presented at the trial as to what the jury instructions are. So I don't know, as we sit here right now, because we haven't done trial, we haven't done calendar call, we haven't done a pretrial. So until such time as you and Ms. Renetti, or if you get standby counsel, but standby counsel is there specifically just to be standby counsel, so it's up to you. You did the Ferretta canvas, and you said that you wanted to represent yourself. You have that right to do that, but it is your responsibility to marshal your case, and it is not me telling you what law is going to be provided. Would be giving you legal advice, and I can't do that.
I like that she didn't spend a lot of time on this other than what she needed to tell him. But as far as the legal advice, she's cutting that right off.
Ma'am, excuse me, forgive me, please, Judge, and it's such a force of habit, forgive me, I have already read in previous filings from, I believe it was Ms. Joby at the time, she was the former prosecutor, is that she put in black and white English in words. She said it is one of the previous judges said the same thing during a hearing. Both of them they both said is that the jury decides the facts and the judge decides the law. And so again, looking ahead, like trying to plan this intelligent, like a sane, rational man, is that my understanding is before you say let the jurors deliberate, is that you're going to provide guidance on the law. So given that, I guess the best I can do at this moment, ma'am, or Judge, is to file an oral motion for you to take judicial notice of NRS 41A.110 and NRS 49A.106, paragraph 6. Those are both for informed consent. In other words, that's part of my defense. And then to take judicial notice of NRS 126.036. That's my right to non-medical remedial care and, parental rights. And then NRS 200.5085, the right to non-medical remedial care. So I am, again, I move the court to take judicial notice of those NRS.
Mr. Sachs, I'm going to interrupt you. If you want to move the court for anything, file an appropriate motion. I do not decide things without an appropriate motion being brought before me and without the opportunity to have the other side to respond to the motion. We are here on the two motions that you had teed up for today. I've made my decision on those motions. As it pertains to what you are asking, I can tell you right now, the court cannot take judicial notice of it can take judicial notice of a statute, but it cannot take judicial notice of whether or not that statute would be applicable in your case. That is certainly one of the stipulated instructions. So, i.e., and this will be the one procedural benefit I will give you right now, is you could state to the court that you want the court to give a jury instruction on one of those statutes that you just cited. And so you would present that to the court at the time of trial as a non-stipulated jury instruction. It then would be up to you to prove with evidence at the time of trial why that jury instruction should be given to the jurors. The same way that the state is going to say, we're bringing charges under this, and they have to prove beyond a reasonable doubt that those charges are appropriate, and those would be instructions that they would give me to read to the jurors based on the facts as they come out during the time of trial. So I cannot take judicial notice as to whether or not the facts that come out at trial are applicable for me to give a jury instruction based on a statute. Now, you can certainly present that to the court as one of the jury instructions that you would like the court to give to the jurors, because yes, you are right. The jurors decide the facts. The court provides the jurors with an outline of what the law is in utilizing those facts to come to a decision. But it's up to what comes out at trial as to what instructions are appropriate to give to the jurors. Does that make better sense, sir?
It does, and thank you for that, Judge. And then I guess the last thing I just want to follow up on is, with respect to Ms. Renetti, are prosecutors legally and ethically obligated in every case to pursue justice by discerning the truth and protecting the rights of all? In other words, victims, defendants, and the community. Is that fair to say? Is that true? Yes or no, Judge?
I would say that a jury trial, that there are jury instructions that say that the purpose of a jury trial is to ascertain the truth. And I would say that a prosecuting attorney as well as a defense attorney has rules of professional conduct that they are required to abide by, and ethical oaths that they take as officers of the court that they take and are required to abide by. So I don't think that I would agree with your word protect, but I would agree that they are required to abide by ethical obligations according to the rules of professional conduct.
Thank you for that, Judge. So the follow-up to that would be, was Ms. Renetti, when I sent her no less than 3 or 4 emails to ask about these things that are in this motion, did she have an obligation or duty to answer my emails?
I will just say this. I've had numerous email correspondence from the defendant. When necessary, I've responded. For instance, he requested, he was missing 2 pages of the declaration of arrest. I provided that. There are things that he's communicating to me that just are inappropriate, and I will not be engaging.
Ms. Renetti has an obligation to respond if it is appropriate within her ethical obligations, the same way that you would be asking an attorney, if you had an attorney that would be asking her questions, that it would be appropriate for her to respond to that attorney. So if it's not a question that she would, and I don't know the context of the questions that you are asking, and I'm not going to get into the weeds on that because I need to complete this hearing, and you can certainly, if there's something that you feel that was not appropriately responded to, you can put that before the court and I can make a decision on it. But Ms. Renetti, any prosecutor that's on the case, as well as yourself acting in pro per as your own attorney. Both sides have ethical obligations, and so you can find those if you were to go on to the Nevada State Legislature, sir, and look up rules of professional conduct. You can see what the rules of professional conduct are, since it's very clear to me that you like to do research, which, and that's perfectly acceptable, and I commend you for doing that. So if you wanted to look up the rules of professional conduct, you can do that.
Another thing I like about this judge is that she'll point him in the direction of where he needs to go, but she doesn't tell him what he needs to know. And if other judges did that, then these sovereign citizens and people want to go pro se would think twice about it, and they know they need an attorney because they don't have the training.
Well, in the interest of settlement and closure of this matter, what is the actual U.S. dollar fine for the 3 felony counts charged against my straw man?
Exactly. Judge, he communicated to my office, he asked that question, I asked him if he's talking about the fine amount that's associated with the felonies that he's charged with.
Yes.
He said no, he talks about crimes or commerce, and I have not responded.
Okay. There are fines associated with the felony that you are charged with as it pertains to the other question that you are asking regarding the straw man account. I understand that is your firmly held belief, that the government is a straw, or that you are a straw man for the government. But there is no, it's only as it pertains, there's fines associated with the felony. So if that's the question that you are asking, we don't know what those fines are yet because we do not know what you are going to be convicted of, sir. If you are going to be convicted at all. So that would require, that would require the court to give an advance ruling, and the court is not in the practice of doing that.
Isn't it fair to say, though, in your bench book or somewhere else, there's a reference point that would say for NRS 200.508, whether it's category A or B, what the maximum U.S. dollar penalty is? Is that not in there or somewhere else within your resources, Judge?
Yes, it is, but that was not a question that you had prepared for me to be prepared to respond to at this juncture. So I prepared for what you had put before the court, and I did not, and I've gone far afield of what you have actually put before the court properly today, and I think that I've engaged in your questions enough for today. If there's any additional questions that you would like to ask the court, you can certainly provide those via written motion, and then that way, the next time I will be prepared to provide you with a substantive answer the way that I was prepared to do so today on your other issues that you did properly bring before the court, because I don't like shooting from the hip, and I certainly don't want to give you incorrect information, sir.
Thank you, ma'am. Thank you, Judge. And so all I want to say is by ending, and this is ending it, is that I respectfully object to your ruling on both of those motions to deny them, and that I take exception with both of those rulings, Judge.
And your exceptions are noted. Thank you very much. Have a good day.
Thank you.
We've watched sovereign citizens in different courts, different places, different jurisdictions, and the script never works. He brought all of that, wasting the court's time once again. But the good thing about this judge, she doesn't let it go on and on and on. She stops it and she moves on, which is good, because we've watched some hearings that have taken way longer than what it should have, just because the judge seemed to be entertaining a little bit more. So anyway, thanks for watching. Give it a thumbs up if you like it. And I'll see you around on the next video. We still have more of these coming along with other videos. So I'll see you around next time.